Hello, my name is Christian Rauda. Maybe you can just try to adjust the slides. Welcome to my talk on fighting legal battles against clones and copycats. Thank you very much for Lerica for organizing this whole convention here, and also to Stefan Klein from Game City Hamburg to make this happen. We're very proud that everybody is here visiting us in our city of Hamburg. My name is Christian Rauda. I'm partner with a media law firm dealing with all kinds of legal questions regarding movie industry, games industry, and publishing industry. And I myself strongly focus on all kinds of legal problems connected with games, licensing, trademarks, and copyright law. Today we'll talk about fighting clones, and there are actually two kinds of weapons we have in the legal arsenal to fight clones. The first thing is copyright law, and the second thing is trademark law. I'll briefly give you a very short overview, also covering several jurisdictions, also highlighting not only on European law, but also US American law. And then I'll have a couple of examples where we can see if there were infringements and how you could deal with those infringements. And we'll have later strategies about pursuing those clones. Does that work as well? The first thing is, when we talk about copyright, is what kind of things are protected in your game. And we'll later see how this actually has an effect on infringement cases as well. We'll have to focus on the question whether there is an individual, a personal creation. And we'll have to make a strong distinction between the idea itself and the expression of this idea. So at least the bar is a personal and individual creation. So anything which is just craft or nothing personal would not be considered to be protected under copyright law. The mere idea itself is not protected either. So if you have the idea to have a certain game mechanic, this itself would not be copyrightable. What is protected by copyright is the expression and sort of the mold this idea actually is grounded in. And it's very, very difficult, and we'll see that in the examples later, whether we talk about the idea itself or whether this is an expression of the idea. Because sometimes the courts say that idea and expression are so closely linked that you cannot separate the mere idea from the expression. So there has to be some protection on this sort of mold together. I'll briefly talk to you about the US law. This is in US code. It says, in no case copyright protection for an original work of authorship extend to an idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless in the form in which is described, explained, illustrated, or embodied in such work. So, if there is a great idea, you can take this idea and come up with a different expression. This would not be considered to be an infringement of copyright law. However, if the expression is taken, then we have sort of another, this is another situation. Which brings us to the question of copyright infringement. There are two different tests which I'd like to discuss with you in different sort of sets of law. One is the German law or European law, and the other one is the US law. Both jurisdictions have established a test to establish whether what we call copycat not really a legal description, but the question if this thing which has some similarities to the original work is legally considered as being an infringement of the copyright of the original owner. And there are two tests I would like to present you. One is sort of the German test, and the question you have to ask yourself is, if you look at those two works, is whether the characteristics of the second work, of the younger work, are so clear and specific and are so in the foreground that everything which was there before, the characteristic of the older work, fades away. So there is sort of in the background some allusion to this older work, but the characteristics of the newer work are so strong that this is sort of merely a background issue. Oh, thank you very much for mending this. And the US law, they developed the so-called ordinary observer test. What does that mean? The question is whether an ordinary observer, unless he is set out to detect the differences, would consider both works, would consider that the disparities are not that different and they're basically the same. So this is the general test. Obviously, it gets tricky when you apply this test to specific works, which we'll now do in the set of specific examples. The important thing is that you have to, in both tests, you will have to focus not on the differences, but on the similarities. So copycats cannot defend themselves by making a so-called laundry list, explaining what they did, that they changed this and that and other things, if the important things have been taken and have been actually copied, so that the overall similarities, the overall games are considered to be the same appeal in their aesthetics. Now, we'll look at some examples, because this is kind of theory and it's very difficult to grasp. Maybe it's easier if we apply it to specific cases. I've got older cases, very old cases, and some cases from recent years. A classic case is the Atari Munchkin case, where actually Munchkin took sort of the same elements because they used the same maze, and they actually also used some of these little dots you could collect to get where the player gets their points from, and they used a Pac-Man style creature with the same V-shaped mouth, and they used monsters as ghosts. And the question now was, the case was tried in 1982 already. The question was, did the Munchkin game, was the Munchkin game considered to be an infringement of the original Pac-Man Atari game? So what the court did was, when looking sort of at the similarities, they obviously had to clear out concepts which were actually state-of-the-art to the specific genre. For example, they said that the existence of a maze is in itself not protectable. But this is sort of the mere idea, and it is fairly standard. They also compared it to, there was a doctrine which was made up for sort of plays and books, and they call it sans affaire, which is the French word for things you will have to do, otherwise you will not get from A to B. In the frame of computer games, there are actually things which are technically necessary in order to arrive at your game, and these technical necessities cannot be considered as original, because it's not, you didn't come up with it, it's not personal, but it's part of the old genre. So what they did, they sort of subtracted the existence of the maze from the idea. So this did not took part of sort of the copyrighted game on the left-hand side. Furthermore, the action of picking up little dots and receiving points from sort of eating up these little dots was also not considered to be original, but sort of part of the overall concept, which was not protected by copyright law. However, what the court stated was original was the existence of this V-shaped Pac-Man figure, as well as the ghosts. They said, well, there is obviously a concept of a maze and sort of people chasing themselves in that maze, but there is no necessity that there should be a creature with a V-shaped mouth, nor is there a necessity that there are ghosts running around. So you could substitute these creatures very easily with any other creature, and the game idea would be essentially the same. So these aspects were considered to be highly original. Well, highly. Nobody had come up before with these sort of combination. And the fact that not only sort of the maze and the overall game mechanics, but also the little creatures were copied. The court arrived at the conclusion, the appeals court, which actually had overturned the court of first instance, that this was considered to be a copyright infringement. I will read out a couple of sentences for you to get sort of a grasp how the court dealt with the case. It says, the maze and scoring table, they're standard game devices. The tunnel is a wraparound, so nothing there which can be copyrighted really. And also the scoring table and the dots. But they say, based on the ocular comparison of two works, they conclude that there is likelihood of success because even though they're not virtually identical, the total concept and feel is substantially similar to Pac-Man. And they also, what they did is they compared these two games to the other games which are in the market, and then set up that there is some significant distances between those. So there was no necessity to take sort of either the Pac-Man figure nor the ghosts. This was basically, these two things were basically the thing which killed the Munchkin game. Now, another example from 2012, which is a Tetris clone. Interestingly, there have been a lot of Tetris cases, and this is one of the recent ones. And the question was basically, is the existence of these sort of the blocks and the way you can move around the blocks, is that part of the idea, or is that also already part of the expression of the idea? I think this is a very difficult case because idea and expression are very closely linked together, and it's very difficult to set them apart and say, well, this is the part of the idea, but this is sort of the point where the expression of the idea starts. So we're in the gray area, and who thinks that the Xeo Interactive game was an infringement of the original Tetris game? Can you show by hands? Who thinks there was no infringement? Well, we're probably a bit more for the infringement. Actually, the US court held that the style, design, shape, and movement of the pieces are expression. They're not part of the ideas, rules, or functions of the game. I think this is a case which could probably also been turned around and could have gone, could have sort of developed also the other way around. But the court took into consideration that at the time of the creation of Tetris, it was sort of a very original thing. Also, the way these little blocks moved, there was nothing like that actually before. So maybe they were generous in that regard. Now, the next thing I'd like to show you is Limbo and Oblivion. And these are actually two different games. It's a bit difficult to see because it's not that dark, but I'm not sure whether you see, maybe the next slide is a bit easier. Maybe, yeah, you should get a sort of a grasp. It is very, very closely graphics taken from the other game. The reason being, I was told that the graphic designer jumped ship and was hired sort of by the other company and then just either took sort of the old graphics or just redid the new graphics with the things he had in his head. This is a clear example of an expression and not the idea itself, and it's very close copying. So this clearly considered a copyright infringement. It's considered a copyright infringement. Which takes us to the point that if there is sort of graphics or sound, or even worse, code taken from another game, this is something you could very easily shoot at from a legal perspective. So these little aspects, not only the game itself, but the little aspects and little elements of the game are copyrighted in itself. Just on a side note, you have not, there is no necessity to file for a copyright, but the copyright actually exists at the time you completed the work. So it's a little bit like fairy dust coming onto sort of yourself after you've completed your work. You actually achieve the copyright by law. Other than trademark law, which you have to register, we'll get to that in a minute. So the good news is the assets of this game are protected by copyright by law automatically, so you could go after other people who take assets or who just only slightly modify those assets and integrate those assets into their game, which is the case here with Limbo and Oblivion. Now, another example from the browser game area. This was on the left-hand side a browser game Travian from Travian in Munich, and there was Wildguns, also a browser game. Now, the interesting thing about those two games are you can see there are some similarities, but from a copyright perspective, that would not be sufficient, because the idea of having a little village and sort of having roads, a little path around it, and there are forests, and this is not something which is original. And the combination, when you take the combination, which is original, you would not say that this is sort of the same aesthetics as the original game. But interestingly, what Wildguns did is that they copied not really the aesthetics from the game, but they copied the balancing. So every character or every sort of group of armor and everything which existed in the left-hand game was mirrored on the right-hand game, and it was not exactly 100% the same, but it was roughly the same, so the balancing was so close that if you knew the left-hand game and if you were proficient playing the left-hand game, you could sort of the next minute go to the right-hand game and just play it because you would know how it worked. And the interesting question is there a legal protection also for the balancing itself? We tried different cases on that issue before German courts. This was not amongst them. I can not talk about those cases because they were all settled. However, they were not won on the issue of copying the balancing. Unfortunately, I always made this argument, but it was very difficult also to convince judges with gray hair and explain to them what balancing is. That was very difficult in the first place. But we won those cases eventually on the fact that also elements were taken which were sort of on the graphics, or we could make the argument that by like a mosaic, everything taken together, it was too close, so it was an infringement on unfair competition law, and we eventually settled the cases and also got very high damages in the six figures for the developers. So until there is new development, the balancing is not yet protected by copyright, at least not under German and European law, but we're still fighting for it and hope to change jurisdiction and judgment in that matter. Now, briefly touch on trademark law. I also said that trademarks have to be registered. So you have to file for a trademark either in Europe or in the US, depends on where you want to publish and market your game. And the trademark scope protection is that you can go after people who essentially use the same or a different title or a close title or a similar, sorry, the same or a similar title for their game. So you can actually attack them on this trademark law basis, and you'll have to file for a trademark so you can go after them on that trademark aspect. Now, the interesting thing is the enforcement of these rights. Now, we have learned that you have some rights, but what do you do if you discover that there is somebody who infringes your rights, and what are the next steps? The problem is that unless you have a very, very close case where you have like a 100% copy, or when there is code actually taken, or one of these Oblivion cases I showed to you, then stores would usually act quickly and will take down the game. However, if you have a case where it's not that obvious, very often the stores, they do not care. They say, well, you fight amongst yourselves, and if there is a result, we'll either comply with the result and we'll pull the game, or the game will be still online. So the question is, what do you do? There's one solution, which I call the lever strategy. And the lever strategy involves that you sort of pick one jurisdiction where you think you have a good case and where legal fees are not high. So you go usually like to a European country, usually not to the US and not to the UK especially. And then you try to obtain a preliminary injunction against those people infringing on your rights, which is an expedited procedure. So it's very quickly. In Germany, usually within 1 week or 2 weeks, you're in possession of such a preliminary injunction. And then with this preliminary injunction, you go to the stores and submit this injunction saying that a court authority was actually shared your view that this was an infringement of your game. With this lever, very often the platforms, they are more likely to pull the game, because otherwise they would contribute to the infringement, and now that they know this is an infringement, they're now part of it, supporting it, because they're actually offering a game which was banned by an injunction by a court, for example, in Germany or the US. So with this lever, you can be successful actually pulling the copycat game. Now, the question is that expensive? It usually is not as expensive as people think, especially developers. They think, oh, if you're going against a big guy, we're never going to have a chance. They've got much deeper pockets. But like in European legal system, it's not a question about who's got deeper pockets, because there is some reimbursement of legal fees, which usually does not exist in America unless there is willful infringement. So usually for a couple of $1,000, $5,000, you can be able to obtain this injunction, maybe even less, depends on the specifics of the case. And you'll have to make an assessment whether this is worth, whether sort of the copycat actually pulls so much revenue from you that it's actually worth stopping him, or if you think, no, we'll not be able to invest that money. So that's now an economic decision you'll have to take. But sort of my mantra to you is, because I very often talk to developers who say, well, if there is a copycat, we're not going to do anything about it. We can't, and we don't have the means, and the bigger guy will always win. I would like to encourage you to look into the specific situation and see whether there are chances, and not completely disregard this option as from the start. Now, yeah, I wrote a book about it. Who wants to read more about it? And I'm happy to take questions and get in touch with you and talk to you about the specifics. Thank you very much for listening. And I think there is now, after the question, there's also a coffee break or a lunch break. But shall we go on to lunch break and have individual questions, or shall we have questions in the plenum? Some questions, okay.
If there's some.
Hello. So I would like to ask about maybe some other cases about when the lawsuit was successful against quite popular game. For instance, we all know that there's lots of Clash of Clans clone on the market, but I haven't heard about like Supercell suing at least one of them, and they have so deep pockets that they can basically crush any clone maker in US, in German court, everywhere.
So what was the question again?
The question is that why are they not doing it? Because there's a lot of Clash of Clans clones out there. They could easily do it, as you describe it.
Well, the question is actually, do they care about these other those other clones? Are they worth the money going after them? That's a question. And the question is also on the specifics. Not every clone you describe as clone is actually legally considered as being a copyright infringement. So it's actually, you have to look at the specific case and just see if the expression is far away with the ordinary observer test. And, some of the clones I know from these games, they actually also had legal support asking their lawyers what it would take actually to separate them from the original, so it would be difficult to go after them. But there are obviously some of them, also some of them I've seen that have either not been attacked, or maybe they have been sort of some agreement that they are licensed. I doubt that, but that could be another option. Let's say, okay, you go ahead, but we'll get a share of everything you sell. It's difficult to look into that because they obviously all sign non-disclosure agreements. What a lot of our clients did when they settled with big companies and got a lot of damages from them. Obviously, the bigger companies, they make sure that people don't talk about that, saying, okay, we got X 100,000 euro from XYZ. So this is why that's kept them secret a bit.
Can I ask one more question about, I understand that you cannot disclose the details, but in general, what was the most popular argument which resulted in court deciding this particular technique or this particular UI copied means that the game is copied? What is usually, well, I don't know, for some genre, the main element which results in you getting the victory in lawsuit?
Well, code is obviously a killer. If you can show that the other party used part of your code or used part of your database, this is relatively surefire. I think the next one would be art and music, as long as it's sort of the same melody. This is obviously very strong. When it sort of goes to the game mechanics, it gets more and more difficult.
And one more question. You were talking about case like Traven versus Wildguns, but there is a different art involved. As I can see, they have a different setting, and we only copied mostly game mechanics. But still, they got kicked, right?
They would. I was not on that case. I heard that there was a discussion, and it's also on the internet that there was some legal battle between them. But I do not think that I'm not aware of a court decision, and the attack on the copying the balancing obviously did not succeed itself. Yeah.
Thank you very much.
Thank you.
I actually have a question as well. So I was wondering, in Asia, especially in Asia, it's commonly said that they should copy the Western world. So how do you fight legally Asian copycats? I mean, is this the same way you do it like in the US and in Europe? Or isn't it a little bit harder, especially since it's the Asian market and they are actually taught to copy the Western world? Yeah,
it's much more difficult, and the only really successful route we explored was then going through the stores. Sort of even like obtaining a preliminary injunction. It's very difficult to serve this preliminary injunction to them, but even if it's not served, it is some proof for the stores that you can obtain a preliminary injunction in Europe against an Asian company if the distribution of that game was made in Europe itself. So you can sort of drag them to Europe and then try this lever strategy. It's very, very difficult to go after them in Asia, and especially for like small developers. This is probably not a feasible way. If you're a bigger company, you could think about that and investing in that. Also for establishing a reputation for going after somebody, because this was also something I discussed with some of the attendants today, that if you're sort of known for going after people, this acts sort of as a preemptive strike, because a lot of people will actually say, no, we'll not copy his games because he's known for attacking other companies for cloning, so we rather take something else. So to sort of gain this reputation, you will have to go after clones, obviously. But I'm aware that in Asia it's a very, very difficult situation.
Okay, should we go for one more question?
Last question.
Yeah, I was just wondering if I may. Should I speak?
Yeah, Patrick, take the mic.
I was just wondering, assuming I'm an indie developer and I have a game in the market that is a copy, and I believe that I would lose a lawsuit, and I, get an email or like a letter from a big international company, would it help just to remove the game and then, hope that nothing happens afterwards? Or do they still have a claim if they say, well, the game was online for a year, now you pulled it down, but that doesn't solve the problem?
Yeah, legally it doesn't solve the problem, because still, if you did it once, there's always the chance that you could do it again. So there is a claim for injunction, legally. There is also a legal claim for damages, obviously, because if you had it online for a year and this was an infringement, you could get sort of part of their revenues as damages. However, very often, sort of the main interest is stopping distribution of the game. So very often, if things are pulled, the original owner of the copyright will say, okay, we're fine. Now our revenues, they're shielded because there is not this competition on the market anymore. And for us, it's not worth going after them and claiming damages or suing for injunction if the thing is pulled from the store, because you will have to invest resources. And especially with Asian companies or other companies, it's very difficult to go after them. So usually the main aim and the main target is to achieve removal from the store.
Thanks.
Well, thank you very much and enjoy your lunch.